Members, while the Nanian Bar Association is not binding on an international body like the tribunal, what is binding is the exit arbitration rules itself. And as Mr. Arbitrator pointed out, there exists a duty under Rule 3, Clause 1, that the tribunal conducts the proceedings in an expeditious and cost-effective manner.
It also has to be a fair matter. And if we're hearing that respondents' counsel does not believe that he can adequately compliant against the conflict on this issue, don't we have to take that into account? Isn't it our obligation to make sure that there is a overarching fairness to the procedure? And so while we do need to consider cost, we also need to make sure that proper representation.
Absolutely, Mr. Arbitrator, we agree. And in the interest of having a fair hearing itself, we submit that since respondents themselves would prefer a continued representation and their resignation is likely to prejudice both our interests, indeed, for a fair hearing, the resignation should be rejected.
Also, this is a question of the council. Yes, respondents say now that it does agree, but what tomorrow is that in the session side presidents that if not properly represented, our whole council is all here repeated that they criticize our own policies and human rights. So shall we not disqualify them on our own motion?
Madam Arbitrator, in our submission to that, there's a two-pronged response. Firstly, no, there cannot be a grounds for annulment of an award later, because such an opportunity has to be such an application would have to be at the first possible instance. And here, respondents themselves are favored and complicit towards a continued representation. But secondly,
just the risks that they say that today, and then months from now they say, watching the evidence of counsel, we've concluded that they have sabotaged the case because of their disagreement with us. Don't we have continuing risks that even if you say as of day they waive an objection, down the road, the facts may develop in a way that allows them to re-argue that point on the basis of
if that is true, Mr. Arbitrator, while they waive their opportunity to apply for annulment, at that point or juncture, they can then choose to disqualify or reject counsels from representing.
So don't we solve all this by letting them out of the case now and avoid those theoretical but real risks by letting them be? This is an unfortunate event that's happening. Bring counsel in and the way the risks is continue to handle those proceedings to the other end.
Mr. Arbitrator, the difference between the two is here the tribunal is the party that tells them they can resolve, and accordingly, a later course of action that arises is respondent then filing for an annulment, stating that the tribunal did not allow it an opportunity to have representation, because as brought up by the respondent counsel itself, there's a Nanian Arbitration Review article which states that DPP is the last law firm representing respondent. Therefore, since their resignation also comes in the absence of any legal available counsel, it cannot be permitted. And in a similar enforcement proceeding of the case Yukos versus Russia, it was held that a counsel walking away in the middle of a representation is likely to prejudice the client. It can only be allowed if there is substitute counsel available to file a motion of appearance.
So just very briefly on this prejudice that your client has suffered, can you just please talk us through, is it only a matter of time, the proceeding can be delayed? And if that is the only criteria, what specific prejudice would a delay of a few months cause in a case where effectively you're seeking monetary compensation and damages? You'll be compensated in the form of interest.
Certainly, Mr. Arbitrator, while the delay is primarily the prejudice clause, in the present case, our assets are sanctioned and frozen under Gyaga until the completion of this proceeding. Therefore, we spend each and every day with our name besmirched, the money owed to us kept away. And this, members of the tribunal, is nothing more than a way to bankruptcy. By the end of this proceedings, when respondent is finally ordered to pay us what we've lost, we may not even be in existence anymore. And therefore,
as a bonus, is there anything in the uncontested facts or any facts of the case that suggest that you are on the verge of bankruptcy?
no, Madam Arbitrator, while the fact that we are on the verge of bankruptcy is not even what we contend, we state that under Article 3 of the Sanctions Law, all our assets, tangible, intangible, any funds that we have are frozen. And therefore, since we are not allowed access to our own resources, every day spent with the money, with this delay, is also forcing us into a very, very bad position. Members, I see that my time is running out. So while I do submit firstly that the resignation is not allowed because of the prejudice it caused, secondly, under the IBA principles and the Hague principles, independence of conduct is required. Councils cannot contend that they cannot represent them. They do have a duty to represent them. The IBA principles read in Principle 5 that there should be no obstruction that stops a lawyer from representing their client. Accordingly, due to the international principles and the applicable legal framework, we submit the resignation should be rejected. Turning now to my second submission, respondent contends that there is no jurisdiction over this investment because of the illegality. An illegality, in fact, conducted by Dr. Fonsworth, the seller of the investment, whereby claimants themselves were duped. We submit that the tribunal can exercise jurisdiction for two main reasons. First, respondent is stopped from invoking the illegality objection due to its own conduct. And second, a bar to jurisdiction is in fact a disproportionate measure to this illegality in question. We also contend thirdly that a sufficient level of due diligence, as pointed out by Madam Arbitrator, has been done in the present case.
I don't want to speak on behalf of Madam Arbitrator, but the tribunal is expressing no findings of fact as to whether due diligence have been involved. That is this question being posed accountability.
Absolutely, Mr. Arbitrator. I mean to say, as Madam Arbitrator pointed out, there's a question of due diligence, and we shall show we've done it. Regarding firstly estoppel, members of the tribunal, it is a well-known fact that the state cannot recognize or endorse an investment and then turn back.
About whom is this well known?
Members, it's an international principle of law that has been accepted in several exit cases. For example, Desert Line versus Yemen. And under this line principle, to phrase this differently, a state cannot have its cake and eat it too. It cannot. I sense a concern, Madam.
Because I thought it would be trouble or compliance focal to this legality argument. Because in practice, they imagine there is corruption over any other illegality. The state often doesn't know this. And there was a recent case, and I think announcement in the morning of Nigeria, before the London Merchant Court, and there are many other cases that states to discover illegality years after and years after the word was rendered. So how can they rely on this focal in the moment of legality?
Madam Arbitrator, in the context of this case, respondents were very well in a proper position to know of any illegality. And further, even after expressly knowing of the illegality, they have still continued to deal with claimants until the response for arbitration. But members, in procedural order 3, that is paragraph 18, to refer page 84 of the record, statement of uncontested facts, my mistake, page 84, paragraph 18. It talks about how the general public here knew of the investment from its inception itself, and to quell the negative press, MK Robotics and its new owner had published a plan. It is also respondent submissions in their memo that a sufficient level of due diligence would have told us that the authorizations were forged, because generally these authorizations were handwritten and not electronic. So members, what we know before us is that there's a council of ministers who usually handwrite or hand sign these authorization letters. They would be well aware since the investment was in the general public knowledge. And despite this, they've engaged.
Where did it say that they usually sign by hand?
Members of the tribunal, this is within the respondent's own response to arbitration as well as within their memorial submission to the party, to the tribunal.
So it's only the respondent's response, but we don't know this.
If I could just have a minute to find it.
You can also, if you want to come back later.
Absolutely. I would prefer that. Thank you so much. In any case, members of the tribunal, after which respondents have engaged in several commercial scale agreements with claimants, and they have purchased drone branches and several more, treating us as a valid and trusted business partner over the last few years. So accordingly, we submit that in line with the principles of fairness and estoppel, respondent cannot now turn back and deny treaty protection to us.
For estoppel, wouldn't you have the burden to demonstrate not only that they could have known that it was forgery, that they actually knew it was forgery, and they still continue to interact with you?
Members, while they do have constructive knowledge, they also have actual knowledge. In a press release dated 30th November 22, they announced that they had found irregularities in the investment. And then, for your reference, on page 11 of the record, Exhibit C3, if the tribunal is with me, this sentence of the tribunal is a tax compliance certificate, and it is dated 31st December 20. The caveat on this reads that it was issued on the basis of information available with the authority, as at the certificate date mentioned above. So even though they knew of the irregularities a whole month before, they continue to deal with it.
But I think it also said that it is automatically generated. Which I believe that the generated certificate and the date did not in any way endorse the conduct of investment.
Certainly, Madam Arbitrator, while it is generated by a computer, this does not mean it is not in fact a certificate from an organ of the state itself. And since they have not in fact stopped any connections with claimant, but only invoked the illegality objection in their response to arbitration.
Council, I'm just going to say that your time is over, but you have an additional 5 minutes to compensate the time that we gave the other side.
Thank you, Mr. Arbitrator. Moving on also to my argument on sufficient due diligence, before which I would address the proportionality. We also submit that an illegality bar is not in line with the proportionality test laid down in Kim versus Uzbekistan. And this test has a 3-step analysis: the importance of the obligation, the flagrancy of the non-compliance, and thirdly, whether the above two significantly then undermine a vital interest.
Also, you mentioned you don't have any case. You mentioned you have just review on the side on this issue. And we need to get to you. And PIT does not make this distinction between different types of violations, which are that the investment shall be made in accordance with the law, very broadly. On what legal principles shall we decide that we create some new principles that if not in the text of the treaty?
Madam Arbitrator, if the VCLT still exists, then Article 31, using the preamble of the BIT, shows us that the very purpose of the BIT is then to promote favorable conditions within the parties, favorable conditions for also investments. And therefore, a trivial violation of law could not and should not be a reason to bar jurisdiction of the tribunal. We submit, therefore, that still the violation in question was not important. The host state itself did not enforce or identify the non-compliance for 2 whole years. There is no intention to defraud the state. Merely, in fact, if the authorization had been correctly applied for, in that case, as evidenced by their treatment of us as a trusted business partner over the last few years, we submit and then there was no flagrancy of non-violence, and rather, in fact, there was good faith. And since the above two are also not prejudiced, further, respondent on finding the illegalities did not take action against the claimants. It also shows us that they themselves.
Yes, just to clarify about the rules of which we apply, the other passage relies on Article 9 during months prior to this hearing, and they're not raising Title now, and they just a couple of days before they changed their position entirely, and they now rely on Article 1. Do you agree with this change? Shall we not postpone the hearing to have a submission to this?
No, Madam Arbitrator, we are okay with having a violation of Article 1 instead of Article 9. In fact, if the violation had been of Article 9, the question of jurisdiction should not actually ideally come up, because as per the temporal scope, if the illegality was made at the time of making or acquiring the investment, those cases then come up to jurisdiction. Whereas if it is while during the scope of the investment itself, then it should ideally be in the merits. But since we have come to a conclusion and we are arguing our issues before this tribunal, we are understanding a violation of both Article 1 and 2.
Shall we not disqualify the council, the opposing party, because their strategy, the legal strategy, being concerned, they don't involve the very important items. They just evolve to question, to challenge the jurisdiction of the tribunal. As you said, Article 9 is just about the merits. So for months they didn't do anything, and actually the English Commercial Court just 1 week ago said that the tribunal shall be more active when they see that non-life is not properly represented. Shall not disqualify them.
Madam Arbitrator, if you do so, you will be leaving this court in a very bad position with no counsel to represent themselves at all. So in that light, we would submit that recognition or disqualification in the current case should not be allowed.
But in principle, we have this power to disqualify them because of their bad strategy, or alternatively, shall we just direct the parties to address the proper arguments that we consider important.
Madam Arbitrator, while I'm not aware of exit jurisprudence stating that a tribunal can, of its own suo motu, disqualify a counsel, if the respondent themselves comes up with a request to have their representation terminated, or if claimants come to you with the grounds that they are not representing them fairly and there is a conflict of interest with counsel themselves, in that case, we would submit the tribunal could then disqualify.
Mark, we're running out of time, and your last point was the finding due diligence. You confused me a little bit by taking us to this argument that if ordinarily in this case that this was signed by the government by hand, and as I understand it, the record, the basis of the argument on the other side, that your due diligence was inadequate with these signatures. Are you, and this, I think this was Reggie earlier, having your case needing it too, is should your clients, should your senior client knew or should have known that it was merely signed by hand, and therefore the use of electronic signatures, because whether otherwise they were probably doing due diligence should have been a flag that led them to do further use.
I understand the concern, Mr. Arbitrator. However, as I submitted, our clients only, our counsels only came to know that this was supposed to be handwritten and not electronic after their memorandums were submitted.
So they should know that you did the government, but you didn't know that they did you the foreign investor.
Not exactly, Mr. Arbitrator, but what we do submit is that why we conducted due diligence is we relied on a local Martinican doctor, Saul Goodman and Associates. In the present case, while they were hired by Dr. Falls for the seller due diligence in the current world of fast-paced transactions, mergers and acquisitions and investments is in fact not an uncommon practice.
It's one that creates risks. In this case, maybe it created a risk that your client did not comply with the law, and that's not right in the treaty to pursue its claims.
Members of the tribunal, I see that I've reached 25 minutes. So just to summarize this answer, 30 seconds. Firstly, as held in Churchill Mining relied upon, it is the circumstances and general business environment around also dictating the standard of due diligence. And in this case, Martinique being a place with booming investments, in fact, had very favorable conditions, lowering our risk. Secondly, Dr. Farnsworth, should I speak louder? Is this audible?
We can hear you. We can hear you, but I'm not sure that we can hear you or.
Thank you. Secondly, Dr. Farnsworth, in the uncontested facts, is an ingenious engine, and we did conduct our in-house counsel reviewing their reports, as laid out in Foresight versus Spain. Even taking out general legal advice from a law firm does constitute sufficient due diligence. Unless I can be of.
Just very briefly, one question to finish the discussion. You saw things all these offenses, and I understand that you're saying that doesn't have any impact on jurisdiction. You will have any impact on quantum, you can just say yes or no.
Madam Arbitrator, while it won't have a specific impact on the quantum, as my co-counsel will go on to submit, we do submit that it will not have any impact on the quantum. Thank you.
And like the tribunal to know that there was a
Thank you, Tribunal. And just to, I think, Madam Arbitrator had raised something about a competent. I think as every counsel in every case, I think we just became wiser as the time progressed in our case. And with this, I now move on to my rebuttals. At the outset, I would like to just challenge the jurisdictional issues raised by the claimants. The claimants largely relied on the fact that the DUR is a trivial violation. However, the foreign investor does not have the capacity to come and decide what is an important law within the state of Martinique or not. As I mentioned earlier, the DUR had a larger public purpose, and that it's not up to the foreign investor to come and interrupt it.
So we're stuck with the record. We're stuck with the record that you put in front of us, but it was, regardless of whether you say it's an important consideration, is there any reason for us to believe that had proper authorization been sought, the government would be not given?
Can I request the second?
Any reason to think that had the authorization actually been sought from the government, the government would not have given it, but was there any grounds for the government to refuse authorization at the time? And that's the point of the claimant that the government had opportunities over the intervening years to know about this investment and didn't do anything against it. And in fact, we don't see anything in the record to suggest the government that in state of illegal investment, except within the four corners of this case. They've prosecuted Mr. Markwood. They haven't done anything against the claimant. So you say it's an important policy consideration, but shouldn't we also look at whether the government actually done anything to act on it, other than make a argument within this case?
Thank you, Tribunal. Without prejudice to submission that the claimant did not conduct due diligence when they had to, I would also like to submit to this tribunal that regardless of whether the claimant wanted to comply with the law or not, ultimately at the end of the day, there was a violation. And even though it may have been Dr. Farnsworth's violation, third-party violations are equally binding on the party.
You were making this sort of triviality. Doesn't matter. Now you shifted to whether there was a violation. But the issue is, can we consider the materiality of the violation? And why should we think in this case it would be anything other than a trivial violation?
As I mentioned earlier, Mr. Arbitrator, the DUR had a larger public interest not to promote and dual use products as well as to ensure there was no conflict as such in any area. So the larger objective of the DUR is to ensure the international security, peace as such. In this particular case, the claimant has not procured. Furthermore, the only reason why we raised concern with respect to the claimant's investment was owing to the fact that on 28th November, there was a GAR report, or the Global Armament Review report.
It's the thing that is government not authorized investment. I don't want to hear about it, but happened years later. The question we're talking about is the moment of investment. And your argument is based on that authorization of the moment of investment. Is there any reason to think this was a material violation in the sense that the government was saying no, and they didn't ask the time?
Thank you, Mr. President, Mr. Arbitrator. As far as this particular authorization is required, the entity responsible to give this authorization is the Council of Ministers. It is not up to the respondent council or the respondent as such to sit and determine as to whether the authorization would have been given if at the time when the investment has been made. It's ultimately the competence of the Council of Ministers to determine this. At the time, if they were dealing with dual-use items, considering the fact that in this particular case, MK Robotics was dealing with dual-use items, then they would have done their sufficient due diligence to ensure that if they have satisfied certain requirements, they would have given the required authorization. In this particular case, at the end of the day, what is before this tribunal is the point that the authorization is not procured, and that is more than sufficient to state that the tribunal does not have the requisite jurisdiction. And
I think your time is out. I got some question again for that, so it was surprising. You mentioned that before, and you needed that you make objections. You could probably, there's probably for its own license jurisdiction as well. You said it's 190 jurisdiction, and it's 190. Could you briefly elaborate what is the primary concern for that jurisdiction?
Sure, Tribunal. I would like to emphasize on the rational material being Article 1, that is the investments that is outside the purview of Article 1 of the BIT, which stipulates that it must have been in accordance with the laws and regulations of the host state. And in this case, it is not so. As far as the rational voluntary jurisdiction of this tribunal is concerned, the very consent of the state to arbitrate is subject to the investor's compliance with the host state law. In this particular case, considering the fact that the violation occurred at the time of making the investment, it vitiates the very consent of the state to this arbitration. And that's briefly the point that I wanted to raise. And if the tribunal has no further questions on this point, I would like to rest my debates. Thank you. Am I audible? Am I audible now? Members, to clarify, we are not contesting whether or not the dual use regulation is trivial. In fact, Article 1, I'm sure, gives us the purpose. We are contesting that Article 28 of the dual use regulation, just this authorization, was considered non-important and trivial by respondent post-state consent. And therefore, because of only a violation of Article 28, which was later attempted to be amended, we submit that the violation should not deserve a bar in jurisdiction. Further, Madam Arbitrator, if I may come back to the fact of handwritten signatures, available for your reference on page 31 in the response for arbitration, line 715. Talks about how the authority signing the authorization decision never applied an electronic signature. And it cites also Exhibit R2, available on page 45. If the tribunal is with me on page 45. The first line talks about original hand signatures with electronic ones. The preceding words are that Dr. Farnsworth substituted the original hand signatures with electronic ones. Therefore, that is how we came to know of the supposed non-compliance.
Just one question. So basically, this electronic signature, there is the same date, 13th November 2020. Does it correspond like to the real dates of the requisition, this transaction?
No, Madam Arbitrator, as given in the procedural order number 3, available on page 98 of the record, Dr. Farnsworth, paragraph 8, that is. Here it states, Dr. Farnsworth utilized the copy and paste electronic signature, with the only alteration being the date. Therefore, the date itself was changed. If I can't be of any further assistance to the tribunal, I shall rest. Thank you. Members of the tribunal, may I just confirm that I am audible? Good evening, members of the tribunal. My name is Saranya Ravindran, and over the course of the next 18 minutes, I shall address the remaining 2 issues on expropriation and the date of valuation. On the first issue, I shall submit that the sanctions law amounts to an indirect expropriation in violation of Article 5 of the BID for 2 reasons. First, that it meets the criteria for an indirect expropriation, and second, it does not fall within any of the exceptions granted.
Just very briefly, this service stage, we still have a problem with jurisdiction, which was not raised in the submission that came last week. Claimants solve part of its effort. It doesn't anymore order or control. Do we have jurisdiction over this solved effort? Either any case law or the case law?
Madam Arbitrator, while I'm not aware of a specific case law on this aspect, we submit that even if it sold 70% of its assets the entirety of the investment, including the trademarks and the IPRs necessary to produce those very assets, remain with the claimant, and therefore jurisdiction as well as compensation can be claimed. To continue with my submissions on the first issue of why the sanctions law amounts to an indirect expropriation. An indirect expropriation occurs when an investor is substantially and permanently deprived of all meaningful benefits of ownership and control. The sanctions law barred our ability to trade our goods, sell our assets, trade our shares, export any product, economic fund, or stock, and in effect rendered the investment completely worthless. Additionally,
but how is this completely worthless if you manage to sell it?
Madam Arbitrator, in this regard, we submit that prior to the sanctions law, there were certain acts that were undertaken by the respondent themselves that severely prejudiced our investment, and I will be addressing this later closer to the issue of valuation, but I'm happy to do it now if the tribunal would prefer to hear that. Thank you, Madam Arbitrator. On the question of permanence, we submit that as held in Veena Hotels, an investment has been substantially deprived of its benefits for around a year. It constitutes a permanent deprivation, and therefore the sanctions law caused an unlawful expropriation. Additionally, under Article 5, compensation must be paid in order to render an expropriation lawful. However, no compensation has been paid, rendering the expropriation in violation of Article 5. Moving to our second argument, none of the exceptions.
Can I ask a question, Counsel? So the traditional conception of expropriation, even with an expanded concept of indirect expropriation, there must be a taking. There must be a taking of an asset. There must be a taking of a business. With sanctions, effectively you have a freeze. The asset may not be deprived of the ownership of this asset. You mentioned Veena Hotels, but the facts of that case were different. There's an issue with the actual use of the asset of the hotel in Egypt not being made available. Again, is there any jurisprudence which actually helps us understand your case that even though there is no taking, the fact that there is sanctions are basically effectively depriving you temporarily of the use of an asset can also constitute indirect expropriation?
Certainly, Mr. Arbitrator, a two-pronged response to that question. Firstly, in an indirect expropriation generally, there's no direct taking as such as held in cases like Metaflat, and therefore this does meet the criteria for an indirect expropriation. Secondly, we refer you to cases like Middle East Cement versus Egypt, where a contract was revoked for the last 4 months, and that also constituted a permanent taking, even though no asset as such was taken from the investor, thereby rendering this as well as a permanent expropriation. Moving to our second submission, on why none of the exceptions outlined in the BIT apply.
Just before we proceed, can you please elaborate the different types of exceptions here? Article 4, Article 6, and Article 8. What is elaborated is the legal nature of this provision different?
Madam Arbitrator, traditionally Article 4 represents the police powers doctrine, granting a general right of regulation, while Article 6 and 8 refer more to the non-precluded measures clause, precluding the application of BIT in the case of Article 6 for all obligations, and in the case of Article 8 specifically for obligations under Article 5. However, all three articles.
In respect of Article 6, shall we interpret this article in light of the necessity provision in the articles, the draft articles for instance, the state, or is it the documents of judgment provision?
Madam Arbitrator, again, two responses to that question. Firstly, we think self-judging is a separate issue on itself, and Article 6, we agree, is not a self-judging clause, and it's to some degree up to the tribunal to determine whether a measure falls within Article 6. Secondly, on the question of Article 25 of the draft articles, it has been held in annulment awards by ICSID that the two criteria cannot be conflated and represent independent criteria, and therefore we apply those criteria itself to show you why the sanctions law does not fall within the BIT.
Thank you so much. Article 8, is there any tribunal that found Article 8 for similar articles, they kind of, if this article is negative, then the Prince powers do not apply because Article 8 it kind of replaces Prince powers.
Madam Arbitrator, while I'm not aware of a case that states that specifically, we submit that the requirements under Article 4, 6, and 8 are quite similar, because if we look at cases like El Paso versus Argentina that interpreted the proportionality requirement under Article 4, and look at cases like Continental Casualty, which interpreted the necessity requirement in a non-precluded measures clause, both of them end up having two key criteria. Firstly, that the measure must contribute to the stated aims, and second, there must be no less restrictive alternatives available. We submit that the sanctions law fails both of those criteria.
Isn't there some practice in the Argentinian case when tribunals said that a state could not be forced to for the best alternative possible?
Certainly, Madam Arbitrator. However, in cases such as Enron versus Argentina, it was equally as well held that if there are reasonable alternatives that are available that are less restrictive, the tribunal does have the ability to state that the measure itself is not necessary. If I may.
Aren't we second guessing the sovereignty of the state when we suggest that the state could have done this and could have done that?
Madam Arbitrator, 2 points to note in that regard. Firstly, the BIT represents a balance between the investor and the state to precisely give the tribunal the ability to give some deference to the state while also adjudicating on the investor's interest. And secondly, the reason why these articles are themselves not self-judging as agreed on the parties goes to show that the tribunal can exercise some discretion on the policies taken by the state.
So in judging it, what is the standard we should be applying? We've got a back and forth about this alternatives. Is that the only consideration, or what should we be looking at to consider whether or not this measure will?
Mr. Arbitrator, we submit that there are two distinct requirements. First, there is a requirement of non-discrimination available in both Article 4 and 8. On the question of necessity, we submit that across tribunals that have both ruled on proportionality and necessity, the availability of less restrictive alternatives remains a constant, and we submit that this tribunal should use that standard as well.
We're entitled to look at the or just see it that.
Mr. Arbitrator, we submit that for following cases like Santa Elena and Metaplat versus Mexico, the sole effects doctrine states that the expropriatory act must be looked at in terms of the effects it has on the investor rather than the intention. However, these exceptions do give us the ability to gauge the intent as well in terms of whether there is a public interest involved in the imposition of sanctions. We want to state that we don't contest that the sanctions might have been well-intentioned. Nevertheless, they fail the test of necessity, proportionality, and non-discrimination. And if I may be allowed to present my submissions on the same. Firstly, on the question of non-discrimination, we submit that a measure is discriminatory when it treats similar entities in different ways without any justification for the same. As for the claimants, the reason why the sanctions law was imposed was to prevent dual-use items from being used in military conflicts. Ironically, 12 out of the 13 sanctioned companies are not even involved in the conflict, and companies like Numeronian Technologies, produced in the exhibit given by the respondent themselves, who have been involved in the conflict, have not been sanctioned.
But what is the appropriate comparator here for the discrimination versus that some companies in multiple military conflicts? So the fact that there is not just all companies from IBO in this sector, right? So maybe this is the appropriate comparator. All companies from IBO's active sector.
Madam Arbitrator, two things to note in that case. Firstly, that then shifts the reason for the sanction from being because of the drone attacks and because of the use of dual-use components to a reason of these are Albany's investments and therefore we have to target them. Which then brings us to the second question on whether that's a justified reason to target investments solely based on nationality. The only justification in this regard given by respondent is that Albany's investors transfer sensitive technology to the state of Albion under the Albion First program. However, even after extensively screening all transactions under the Albion First program, such transfer of sensitive technology has not been found, making this justification lacking in any evidence. Thus, we submit that the sanctions law is discriminatory in nature and cannot be justified by the exceptions. However, even if the tribunal disagrees, we further submit that the sanctions law does not meet the threshold of proportionality and necessity. As stated before, this has two prongs. First, the measure must contribute to its stated aims, and second, there must be no less restrictive alternatives that are available. On the question of contribution, we submit that it is not the claimants who sell these components to military actors, but rather intermediaries who unlawfully buy components from claimants under the guise of a commercial use and then resell these components to military actors. If claimants are sanctioned, then these intermediaries can easily shift to other companies who have not been sanctioned under the decree, such as Numeronian Technologies, to procure the same components.
So I hear the point, but we also have to take the view that what can the state do? It can only regulate companies within its jurisdiction, right? So even if there might be other contributors to the conduct they're trying to avoid, aren't they entitled to some measure to say we can only deal with what we can deal with, which is companies within our country. So even if they can't solve a problem, ultimately, aren't they entitled to take the steps they can take in order to address that problem to the degree they can?
Mr. Arbitrator, I understand your concern. Again, a two-pronged response. Firstly, as referred to in the GAR report they themselves cite, it recommends that the lines of supply need to be first identified before undertaking any measure. But secondly, we submit that respondents are uniquely in the position to take these measures, because if we look at the kind of measures they have already taken, they have an FTPG group with the ability to coordinate with each other and determine the lines of supply, and they have targeted specific companies in the past, such as Sonblas Corporation.
So I keep indirectly answering these blocks. I keep thinking I'm hearing you say that they have another motivation, but you're not saying that. So do we care? Do we think that is your argument that this was protectionable, and they had another reason that they used these measures, and we should take that into account, or are we ignoring what their actual motivations were and just looking at the consequences?
Mr. Arbitrator, we in this tribunal do not want to speculate on what the intents of the respondents could have been, but merely are looking at their sanctions law from an objective lens to see whether it meets the criteria of necessity, proportionality, and non-discrimination. While the reasons for not meeting these criteria could be diverse, we submit that that itself is not relevant in as much as they don't meet the criteria per se. Additionally, we submit even if the tribunal disagrees that the measure could contribute to its objectives, we state that respondents had other less restrictive alternatives. As per the statement of the uncontested facts, goods traded within the domestic jurisdiction of Martinique remained in Martinique, with only exports being transported to military conflicts. So at least domestic trade should have been permitted. Additionally, under the sanctions law for Numeronian Technologies, for instance, only dual-use components sold to Albion for military purposes has been sanctioned, whereas for claimants, all components for any use to any state has been sanctioned.
So this pulls together discussion you had with one of my colleagues a few minutes ago, and I have to admit I don't fully understand the effect of the sanctions law. So it's arguing that if more proportional sanctions law, for example, would allow your client to sell its business to a market. One proportionality issues here is the degree to which sanctions law goes beyond things that are necessary for a goal, purpose behind it.
Yes, Mr. Arbitrator. Our submission is that the sanctions law goes way beyond what is necessary, and at least some leeway would have enabled us to
continue performing economically and would have been more justified. If I may be allowed to move on to my second issue on the date of valuation. Thank you, members of the tribunal. We preliminarily submit that the tweet by Mr. Organa is attributable to the state, and therefore any effects of the tweet cannot be taken unfair advantage of by the respondent. On the question of attributability, under Article 7 of the Articles of State Responsibility, a parent exercise of authority is also attributable to the state. When Mr. Organa tweets from his official account on trade issues directly related to his competency as the head of a trade committee, he is acting within his official capacity.
So 2 points of clarification. I'm taking it from the way you put this, that you accept that it's not attributable state, then evaluation date must be later. You are accepting the attribution necessary in order for the valuation date to be heard.
Mr. Arbitrator, we're submitting, yes, that attribution is one component that would be necessary, but alternatively, there's also an FTPG meeting that happened on 2nd December, where respondent clearly stated that restrictive measures against Albion would be imposed.
But in your own case, some form of government action is necessary.
Certainly, Mr. Arbitrator.
I just want to get clarification. And then, since you were going there, the tweet doesn't say that we are going to sanction. It says we should, right? So how do we get from, even if it's true that the representative of the state in your theory isn't saying it's what happened. It's saying it should happen, let's do it. And so therefore, if we take some of the comments about a future requests something happen in the future to be the moment in which the expropriation should be valued.
Mr. Arbitrator, if I may take an additional minute since I've run out.
I think we will around 3 minutes because we used more time. We gave 2 minutes more to the other parts of the first issue.
Thank you, Madam Arbitrator. A two-pronged response to your question, Mr. Arbitrator. Firstly, we need to look at the tweet in conjunction with the circumstances surrounding the tweet. On 2nd December, there was an FTPG meeting where the state initiated and put out a joint statement that restrictive measures against Albion would be undertaken. And if we look at the title of the sanctions law, it states restrictive measures against the Federation of Albion. And when we put the tweet in context of the FTPG meeting, it's fairly clear who is going to be targeted by the sanctions.
So it doesn't really answer the question. It's simply that even that is a proposal to do something in the future. It's not doing something yet. And obviously the scope of what will be done will be entirely clear at that stage. People may have wanted, people in the government may have wanted this, but until they do it, how can we say an expression of desire is equivalent of an action?
Certainly, Mr. Arbitrator. In this regard, we refer you to the case of C.P. Davis, where the tribunal explicitly held that we cannot allow reduced compensation for diminution in value caused by the state. And here are 2 points directly responding to the question that you asked. Firstly, the tweet, regardless of what it said, because of the indications it gave, did cause a devaluation, regardless of whether it suggested or stated that sanctions would be imposed. But additionally, as held in C.C. Davis, if we did allow a reduced compensation, that would mean that a government official could simply announce an...
If the sanctions had not subsequently been imposed, but the tweet was made, and there was market turmoil because we can find a way.
Mr. Arbitrator, we understand in that case, we wouldn't have a claim because the sanctions law completes the expropriation.
Okay, so you need the sanctions law to complete the expropriation.
2 points on that, Mr. Arbitrator. We both need the sanctions law to complete the expropriation and use the sanctions law as evidence of the fact that the tweet and the FTPG meeting did generate genuine concerns. While the tribunal and the clients might have disagreements over what the tweet represented, in the market, the tweet was very clear in the state of Martinique, causing a 60% devaluation. Given it created this massive impact, as held in cases like Cardisopoulos versus Georgia and in C.C. Davis, a state cannot cause a devaluation and subsequently take advantage of its own acts and pay lesser in compensation. Therefore, the valuation claim in this regard should be made on November 20th, rather than on December 24th.
Is your argument effectively that the indirect expropriation commenced with the creed and was completed with the sanction law?
Mr. Arbitrator, we make two submissions. Firstly, that creeping expropriation in terms of commencing with the tweet and completing with the sanctions law occurred. And second, even if the tribunal does not hold a creeping expropriation, the fact that there were state acts that caused injury to the investor prior to the expropriation is by itself sufficient to raise a claim of prior compensation. Lastly, we submit that as held in cases like Casa de Valores versus Russia, if there is an anticipation of expropriation creating a depressed market, then that should not be made the basis of compensation. So regardless of the clarifications that were released, given the sale price continue to represent a fear that the investment could be expropriated, we don't think that that sale price should be made the basis of compensation, and instead November 20th should be made the appropriate date of valuation. If the tribunal has no further queries, I rest my submission with this.
Thank you so much. I think at this stage we don't have further queries. How much time was used?
1 minute.
1 minute on top of 3 minutes, or 4 minutes. I think we will grant additional 4 minutes to the council on the merits to opportunities to do this one.
If I may start, members of the tribunal. A very good afternoon, members of the tribunal and counsel for the claimant. My name is Akhil Tiwari. I'm the co-counsel for the respondent. In the next 19 minutes, I will be addressing the issues on that. For the tribunal convenience, I'll be mirroring the issues as raised by the team. Members of the tribunal, the Republic of Martinique is a very developed nation. It is developed because its citizens have worked hard in order to innovate advanced technology and resources.
They work hard, but now there is some state ban opening for participate in that life.
Madam Arbitrator, the citizens of Martinique still work hard. They work hard in order to innovate advanced technology to be used for the betterment of humankind. The sanctions imposed on the alien, these are the investors who are using this technology to be used in military equipments, to be used to kill innocent civilians, to be used as conductor of death. The Republic of Martinique has always welcomed foreign investors, including the alien. But as they kept on using Martinican resources in military conflict, the sanctions law were invoked in this particular case, which has led to the present dispute. At the very outset, of the period. And my second submission is that even if there is a violation of Article 5 of the BIT, the date of compensation should be 27th of December 2022.
You said the date of compensation, the date of violation. Is there a difference?
Madam Arbitrator, the date, I would say date of compensation because I believe this is still a law of expropriation or a law of expropriation. That's why date of compensation should be If there are no preliminary questions, I'd like to proceed with my first submission. In regard to my first submission, the claimant has submitted that there is a violation of Article 5 of the BIT. Before I state how there is no violation of Article 5, the measures were invoked in pursuant to the power provided under Article 6 of the BIT. Article 6 as provided at page 91 of the PDF expressly authorizes the signatory state to invoke necessary measures in order to restore.
You are not relying on form and form.
And if the tribunal doesn't consider the measure to be necessary, then it's my alternate argument that the measure is in pursuance of the police power of the state.
But what is the legal nature of this provisions regarding these powers and the Article 6? What are the sequence shall be considered one article and then another article?
The Article 6 requires a measure to be necessary and hence has a higher threshold than a measure which is invoked under Article 4, the police power of the state. Hence, a measure should be seen if it is necessary first before going into the provision of Article 4 of the BIT. Hence, the respondent invokes Article 6 before going into the provision of Article 4. In this case, the measures are indeed necessary in order to restore the international peace. In this case,
Council, you will be coming to this anyway, but could you just tell us or guide us about the criteria of necessity over here? Is this really a self-judging mechanism where you as a state say, we are sovereign, it's in our gift? And to what extent do you think this tribunal, what criteria, if any, should the tribunal be applying to determine the necessity of the measures?
And if we follow up the second question, do we agree with the opposing party's submission of how we should observe the sensitive violation of international law or not?
Madam Arbitrator, I do agree because they have also invoked the Continental Casualty versus Argentina case. In this particular case, the tribunal has held that the measure is invoked under Article 6 is self-judging. In this case, the test of requirement of necessary is to be seen if the measure, if there is no other alternative measure available, and if the measure is apt and decisive to be invoked.
Sorry, you said that this is the self-judging provision. Why is this so? Is the wording different from the continental casualty case? This case.
The facts are different in continental casualty and in this, but there is a similarity of national interest. In that case as well, the provisions are invoked in order to restore the international, in order to protect the national interest of the state. And in this case as well, the national interest.
Sir, just because this is theoretical point and the your submission, shall it not have a wording that the state can adopt measures it considers necessary, in each case it will be a self-judging provision. If you don't have this wording here.
Sorry, Madam Auditor, can you please rephrase the question?
Yeah, I think in the continental casualty, the wording was slightly different. The wording of the BIT, it said that the measures, the state can adopt measures it considers necessary. The state itself considers necessary. We don't have this wording here. So why should we follow this pattern?
Madam Auditor, indeed, the particular considering word has been missing from the provision, but the both of the provisions have been taken from the very same gap principles and have been very material, and hence the tribunal can consider aspiring from the tribunal which has decided on that particular provision. Moving ahead, the requirement of necessity still remains the same. That the measure that there is no other alternative measure available and it is apt and decisive in order to restore the international peace. In this particular case, the international peace was indeed disturbed on 25th of December 2022 due to the drone strike.
It said, I'm thinking about this international peace. Basically, the article it said the treaty shall not recruit and involve further the fulfillment of its obligations with respect to the maintenance or restoration of international peace and security. What are the state's obligations? Maybe can you give me an example of the United Nations Charter or any other obligation? What are the state's obligations to maintain and restore the international peace and security?
We are the members of United Nations, the respondent state, and in the United Nations Charter objective, as well as in Article 1 of the United Nations Charter, it's very clearly provided that the purpose of the United Nations are to maintain international peace and security, and to the end to take effective collective measure for prevention and removal of threat to the peace. In this particular case, there is a threat to the peace, and it has already occurred.
Yeah, but doesn't the United Nations Charter say that the Security Council is the only body authorized to maintain national peace and security?
But we should also look into the facts and circumstances prevailing in the region. The lives were lost, 14 people have already died. If the respondent state would have waited furthermore and for the United Nations to grant the permission, for more life would have been cost. For past 1 year, the claimant have been exporting the products. People were being died. If a further delay would have been allowed in this particular case to take approval from the United Nations, or then more life would have been cost. Hence, it was necessary for the respondent in the exceptional circumstances which will be prevailing in the region in order to invoke these necessary measures as soon as possible.
One question in your presentation. You said you're in the region, you made it in the region, but isn't Martinique an island state located not very close to this military conflict by hardly current mean?
Madam Arbitrator, the measure has been invoked in order to restore international peace. The peace was disturbed internationally in the Burundi conflict. Moreover, we can't say that these kind of attacks won't occur in other part of the world. The drone which was used in the Hawaii militia was produced by Awakened Republic. These particular drones were also used in different uprisings around the world, including the Syrian uprising and the attack on HMS Escopete. This shows that this threat was for the whole world and not only related to the world.
What are we entitled to consider when we consider the applicability of Article 6? Do we stop with a statement from the state that its measure is for the purpose, got the end, the state said that we're done? Are we entitled to consider whether it objectively was necessary? And are we entitled to consider whether it is necessary to an obligation? What is the state's view of the standard was? You're arguing about the language and content of thought casually and whether that allows for some judgment, but assuming your view of that, is that the end, or can we go further? What are we entitled to look at and consider?
Mr. Arbitrator, we concede that the measure is not self-evident. The tribunal still, in order to see if the measure is necessary, they have to see if there was other alternative measure available at that time, or if the measure is apt and decisive in order for the objective of which it is imposed. In this particular case, both of these conditions are fulfilled.
Does it matter what the intention was, in the sense that if we were to conclude that there was another purpose other than this, are we entitled to consider that, or do we take it on face value that it was for this purpose?
The tribunal has discretion in order to see if the measure was indeed taken for the purpose of what it was invoked. The objective for invoking the measure in this case is to restore international peace. Hence, the tribunal has all the power to see if that the measure invoked for international peace was indeed in order to govern that area. Was it proportionate or not? Or if there was another alternative measure which could have been invoked to restore the international peace. In this case, there was no other alternative measure available.
And we should ignore any evidence in the record that suggests that the motivation might have been economic.
Mr. Arbitrator, the motivation has never been for any economic gain. The objective of the sanctions law has very clearly stated that the sanctions are indeed imposed because of the admin first program, which was to export critical technology to be used in military equipment around the world. This was a mere apprehension by businessmen because of the illicit activities carried out by the Algerian investors.
Actually, the minutes of the parliament on their respondent, they clearly say that they didn't consider any that this impact in the far away in very remote region will not affect the national security in any way. And the only effect that it will have after the respondent is the effect on its economy. So how will you address it?
Madam Arbitrator, first of all, the meeting happened on 23rd of December. The attack happened, the drone attack happened on 25th of December. The sanctions were imposed on 27th of December. Indeed, the parliament meeting said that it is not related to the region. There is no national security because there is no harm to the region itself. Hence, this is a contention that the measure is invoked to restore the international peace. It's not to save our own national security. There is a national interest, but not a harm to the national security of the Martinique state. We still stand on the words as said in the parliament meeting. The measures were invoked to restore the international peace, and there was no harm to the national security of the state.
But in general, if you have if you see that there was maybe not, but probably some other purpose that would protect its economy and to just protect national companies and benefit for business in this field. Is there a way for us to consider if we have two potential public purposes? Is there any legal concept which will allow us to look behind the officially announced public purpose?
For that, I will raise a proportionality measure. In this case, as I stated before, the objective is to stop the illicit use of Martinican resources for military equipment. The objective in this sense has been limited to even the claimant investment, other than their investment in dual use regulation, which was fixed for military equipment, no other investment of theirs has been touched. If this particular sanctions power imposed for any economical gain or to damage claimant investment, then all of their assets would have been freezed. But the claimant themselves, in page 4, paragraph 17, has accepted that only their principal business is affected. If I may invite a tribunal to page 4, paragraph 17, 4 lines from the bottom of the paragraph. If I may read for the benefit of the tribunal. Martinique introduced a new sanctions regime with law degree 134/02, freezing claimant assets and prohibiting principal business operations of MP Robotics as a manufacturer of dual use goods. Maybe their principal business has been affected. Their other ancillary investment and business are still with them and they can still carry it out.
Can you please give us any indication as to the ratio between principal business and subsidiary business for us to understand the implications on their overall business?
Sorry, Mr. Arbitrator, the fact sheet is oriented on this particular one.
Doesn't that indicate that the principal business is actually the material part of the business and the other business is actually fairly inconsequential?
Mr. Arbitrator, even they are inconsequential. It shows that they are still, but they still have the power to take control over them. They can still exercise their control over those assets. The point is, if the respondent motivation was to damage their investment, we would have freezed all of their assets and not only the principal.
They're entitled to sell this equipment to companies.
No, Mr. Arbitrator.
Are they entitled to sell this equipment to companies in countries other than Albania?
No, Mr. Arbitrator. They're not entitled to sell the assets which are freezed.
So how does that accomplish the goal of international peace and allow them to sell to other companies?
Mr. Arbitrator, the sanctions were imposed because there are a few different reasons. One of the reasons is because of the Albion First program. The Albion First program.
Okay, so how does so quickest, let's come back to that because that suggests that there is an economic reason that's disconnected from the war. And second, how does preventing them from selling in countries other than Albania accomplish the purpose of the sanction law?
It accomplishes the purpose because it was very pertinent regarding the facts and circumstances of the region to stop any Albion investor from selling any resources of Martinique to any other country.
It just told us, and as I read the law, I said earlier, I'm confused by it because it doesn't let them sell to other people in Martinique. So how does that's inconsistent with what you said the purpose of the law is.
Mr. Arbitrator, the purpose of a law is to ensure that the products are not exported from Martinique to any other region. I accept it. And because it should also not be exported or sell to any other Albion investor as well. Because in February 2020,
you keep repeating that. My question is, they can't sell to other Martinique companies either, which doesn't fall into the two categories you could identify: export or Albion companies. They can't sell to anyone.
if it was that,
directly contradictory to what the section
I understand your concern, Mr. Arbitrator, but we'll have to see that before in February we had imposed something very similar to what we have been suggesting. It was we have amended the dual use regulation, which was to ensure which was very similar to the trade embargo for the exportation of the product. They were allowed to sell internally or even externally their investment. But even though these regulations were in place since past 1 year, the Albion was still able, Albion investors, including the claimant, was still able to export the products out of the Martinique into military conflict. Hence, this time it was very necessary to impose a measure which doesn't allow them to sell the asset to anyone.
You could, if you wanted to accomplish that goal, the law should be that no one Martinique can export, rather than this company can't sell Martinique. That's what I'm struggling with. You keep telling us the purpose, but then you tell us the law does something different from the purpose of the purpose. Anyway, I think we need to move on.
Mr. Arbitrator, if we would have imposed a trade embargo on all the complete on Martini, then that would have been disproportionate. Only the Albion investors, the claimant have been found to be involved in the military conflict in the GR report, in the investigation held by the FTPG and the respondent on 2nd December in the Peter Wars support and the Albion joint venture with the
not to be disproportionate, we were discriminatory.
We were not discriminatory, Mr. Arbitrator, because there is a reasonable justification behind imposing the sanction stop only on the Albion investors. As I stated before, because only these investors, including the claimant, were found to be involved in exporting the critical technology to military equipment.
Because I'm talking about sales that are not export sales, which are prohibited by the sanctions law. You're running out of time, so let's move on.
With this, I conclude that the measures are indeed necessary in order to be invoked, and hence there is no violation of Article 5 of the BIT. There is no discrimination, and the measures are proportionate as well. Moving ahead with my second issue, which is regarding the valuation of the asset.
I think this time over is without valuation in this right, the valuation was it 5 or just 4 things.
Thank you, Madam Arbitrator. Moving ahead with my second summation regarding the valuation of asset if the tribunal finds that there is an expropriation. The respondent humbly submits that if there is an expropriation, still there is no compensation due from the respondent to the claimant. And this has two levels of arguments.
But wouldn't it be more correct for respondent to contest the jurisdiction over these assets?
Yes, Madam Arbitrator, and as like the claimant themselves, while you asked the question regarding jurisdiction for its assets sold, have never talked about it, stating that the assets which are sold doesn't even come under the jurisdiction of the tribunal. Hence, for the assets that are sold, I had my arguments, but as the claimant themselves have backed off that it doesn't come under the jurisdiction of the tribunal.
Is there any case or any rules or whether the tribunal shall have jurisdiction even if an investor sold the assets before initiating the proceeding?
Sorry, Madam Arbitrator, the council please ignorance. I have no idea about any case law of precedence in this regard. But if we see logically as well, the assets were sold on 24th of December. The sanction clause was imposed on 27th of December. Nothing prior to 27th was notified on 27th of December. Hence, nothing prior to 27th of December can be attributed to the respondent. As there is no obligation for us to pay any compensation or damage for asset which was from 24th of December 2020.
You are saying that just because they sold the asset, now they don't owe any compensation. I wonder how is this reconcilable with the fair market value standard on which your team relies, because it's different from, there is an income-based approach and the market-based approach. So the fair market value usually is not assessed based on the one single sale. They should still make a projection of cash flows in the future.
Madam Arbitrator, even if we take the standard of fair market value, it talks about when there is a willing buyer selling it to a willing seller. In this case, we accept that there was a market fluctuation. But the market fluctuation was because of the GR report, which was produced on 28th of November, which clearly stated that the claimant products are involved in the Wadaki conflict, are being used by Awaken Republic. The people of Martinique reacted to that particular news as we hold our resources and technology at very high regard. Yes.
And a tweet of the 2nd of December had no impact on the market fluctuation.
I accept that the tweet might have had some impact on the market, but the tweet was tweeted in a personal capacity by Mr. Veermana. As the market was going through the new allegation of the claimant asset being formed. Yes.
So do you agree with the claimant that the articles that they shall apply the test of attribution from the
No, Madam Arbitrator, the Article 7 should not be applied in this particular case because Article 7 states that it will be respondent, the state is attributable if the statement is made in the public by a person of authority. In this particular case, the statement was made in personal capacity by Mr. Great Organa. The timing of the tweet and the content of the tweet should be looked at. The timing of the tweet is 3 a.m. at night. The content of the tweet has emoji rated and which states that it was mere a personal opinion of Mr. Bill Organa as other citizens of Martinique had at that time due to the GI report which was published. Mr. Bill Organa has a freedom of speech. He utilized it, he made a statement, and hence it was a personal opinion of Mr. Bill Organa, which he himself clearly stated the very next day on 16th of December in a TV interview as well. Moreover, the nation's party leader, Mr. Albert Emlyn, also denounced the statement on 17th of December. It's also pertinent to note that on 23rd of December as well, the Parliament of the respondent state has again very clearly stated that no sanctions will be imposed. Even though they were very clear statement, the claimant went ahead and sold the asset on 24th of December, the very next.
Yes, I think your time has expired, but I will ask a question and then you can bring it up. If we agree with you that the moment of expropriation was in December, does it necessarily mean that the date of valuation shall be at the moment shall coincide with the date of expropriation, or can the tribunal move the date either before or later in this case?
The FMB standard states and the compensation as well is to be paid when the public knew that the sanctions law will be imposed. That's the date. The sanctions law were imposed on 30th of December. But as the notification came out on 27th of December, we accept that the date of compensation, if the tribunal decides to pay, should be 27th of December, as the public knew about the sanctions law on that particular date. If there are no other questions, I would like to conclude my answer.
Yes, I think I have a general question. Sorry, everyone, for today. Just one last question. In principle, let's forget for a moment about this case. Do we have power to move the date of valuation in some cases to the prior date, and in some cases to a subsequent date, so that it will not coincide with the moment of expropriation?
The tribunal has power to move the date according to their understanding when the market was affected by the sanctions law. If they believe that the news regarding the sanctions were imposed prior to the date which the respondent submitted, they have all the power to move the date in that particular regard. So no other concern. Thank you, Madam.
I think there was some mistake amongst that of time, right?
5 minutes ago.
Yeah, I think we can both sides can keep it relatively short, so that we don't extend it in another 10 minutes, unless the final subject to that. No objections?
Before I begin, am I audible? 3 points of rebuttal. Firstly, they rely exclusively on Article 6 of the PIT, and there's another crucial distinction we must draw between Article 6 and Continental Casualties, Article 11 of the US-Argentina PIT. Article 11 had an or provision where any of those measures could be taken as an objective, whereas Article 6 states and the protection of its own national security, implying that all 3 objectives have to be met. However, respondents themselves have acknowledged that their own national security is not hurt in this particular circumstance, precluding the application of Article 6. Secondly, on the question of the sanctions law prohibiting only principal businesses, we submit this is patently false. While the claimant's submission states that our principal businesses were hurt, it does not state that no other businesses were ever hurt. And in fact, Article 3 of the sanctions law states that every asset of every kind has been frozen, clearly showing that no business has been allowed under the sanctions decree itself. Lastly, on the question of valuation, they state that the mere presence of emojis and nighttime would imply this is not an official tweet. However, globally, it has been recognized that these can amount to official statements. For instance, a US court in Night First Amendment Institute versus Trump held that Trump's tweets could be considered an official act.
How do we deactivate the effect of the tweets and the effect of the news? Because obviously, the dollar itself is going to raise in investors' minds risks around it. So don't we also have to say that there was independent things that created the not related to the conduct of your client's business? And they're necessarily their intentional conduct. And don't we have to extend that we can't happily blame states for something that was somebody called too low.
Apologies for asking for an extension. Could I just have 30 seconds? We submit that the standard for causation is not that an act should be an exclusive cause, but rather that it should be a proximate cause of the devaluation. And the tweet.
But you're asking the full consequence against valuation.
Certainly, Mr. Arbitrator. And that is because if we look at the Martinique Herald newspaper report, it very clearly states that it was after Mr. Organa's tweet that it sent shockwaves around the world. And in fact, the title of the report itself reads,
any investor thinking of buying the fund's business would be concerned about the borrower forward. Management, because it's going to raise the possibility of liabilities, of sanctions, all sorts of events that would take place. So while it may not be the entire cause of maybe things, it means there's going to be a reduction in value because of the consequence of your client's business, not just the benefit of sanctions, but like I stated. And there's that effect of consideration of what we should decide the valuation rate should do.
Mr. Arbitrator, we beg to differ on this point because even before the GAR report, as noted by the respondent themselves, details were found in wars. And after that, when the evaluation was done of the company on November 24th, it was stated that profits were expected to increase and such fears were not found. Thus, we submit that in this case, the date of valuation must be held prior on November 20th.
Members of the tribunal. Stating in my rebuttal, the first allegation put on us is that we have stated that no national security interest was harmed. Yes, it was not harmed, but there was national interest involved in this. The national security interest has a movement of national interest involved, which was for critical technology being exported. Moving ahead.
That means you accept claimant's proposition, though, that we have to read Article 6 as requiring the last clause, and the protections of national security is a requirement along with the previous clauses in that in Article 6.
No, Mr. Arbitrator. We still stand that
Shouldn't say
it says or and
that's it. Comment and now it's point
it says public order or to restore international policy. Is an or after the maintenance of public order.
Yeah, and then there's a comment and end. And your argument is the comment and end means that last clause applies to all the previous three options plus. And so are you accepting that plus has to be there? The plus being that any of those three have to affect the protection of national security.
Stating that even if the statement is that this particular thing was also discussed in continental casualty as well. The provisions, the obligations inside Article 6 were not read collectively. If the tribunal still consider them to be collective, our submission is that national interest was still harmed.
So your submission is national interest is national security.
Our submission is the national interest is in this particular case, the national interest does paramount to the national security of the state. Moving ahead, the second to the article, the claimant has stated that Article 6 says that all of the assets were freezed. Article 1 of the sanctions law very clearly states that only the dual use regulatory equipments assets which used to deal with dual use regulations are to be frozen under the sanctions law. Article 4 as of sanctions law again reiterates on the very same point that nothing other than the assets dealing with the dual use regulatory goods should be imposed under the sanctions law. Moving ahead, the claimant has stated at the very last, equating the tweet by Mr. Bill Organa to the tweet by Mr. Trump. It's very pertinent to note that Mr. Trump doesn't come on TV the very next day and states that and denounces his own statement. In this case, Mr. Organa has done, and hence it should not be equated. Thank you.
Thank you so much for this great round. I think the teams deserve a round of applause. We will not deliberate now, so we will probably ask or
So for the deliberation, I will request everybody to move to seminar hall where we will have the right ceremony. The arbiter will be here.
Thank you so much.
Thank you. Good luck.